Thanks to Chris Marsden and to Chris Avery, and thanks to everyone here for turning up. Memo to all the practicing lawyers in the room: do yourselves a favour tomorrow morning and send a link to the Centre's website to all your corporate clients. Be assured you will not regret it, nor will they. In 20 years as a Clifford Chance partner, I chased any number of ambulances, but I rarely scored more highly in marketing terms than when I brought the Centre's existence to the attention of General Counsel, because you would be surprised, even now, the number of General Counsel in FTSE companies who are unaware of the Centre's existence, not least because other parts of their companies may not have told them of the Centre's existence. And flippancy aside, they will thank you for bringing such a comprehensive resource and such a transparent exercise in civil society dialogue to their attention. It worked for me and it will work for you. I'm going to say nothing about the Ruggie mandate. Clifford Chance has contributed to its work and supports it and awaits its conclusions with interest. I want to offer 4 very quick pointers to the future, and they're these. The first is that I anticipate that in the UK and in a number of other so-called developed countries, the relationship between business and human rights in the coming period may be viewed through an anti-corruption prism. British corporates are currently feeling very vulnerable in a good way because of the introduction of the UK's new anti-bribery legislation. The government has been coy about introducing guidelines which will explain how the statute will work, but I would estimate that at least half the publishing activity of London's finest law firms, and that's an industry in its own right, is devoted currently to bribery law. And I think the NGOs in the room should be seeking to exploit that nervousness and seeking to make the case that they wish to make for their own particular organisations within that anti-corruption kaleidoscope, because you may be heard more enthusiastically than you were before. A parochial point, but of some importance to me, is the fact that my whistleblowing charity, Public Concern at Work, has seen an immediate step change in inquiries with people seeking to understand how independent whistleblowing helplines will work, because it's the establishment of sustainable frameworks which may offer you some defence otherwise to a charge of complicity in bribery. So I think the whole anti-corruption space is going to be very dynamic in the time to come. You're going to witness, I foresee, the deployment and appointment of dedicated, standing, independent compliance council in the manner that BAE did some months ago. I suspect that's going to be a trend that's going to be replicated by others. My second point, it's always interested me that there has not been much attention paid to the way in which business across the world since the introduction of the UN Declaration has been very adept on its own behalf in opportunistically exploiting human rights. Now, conceptually, I've got no problem with that. That's perhaps something we can canvass in discussion afterwards. I don't think any UK judge is going to displace industry's determination to enforce rights to property anytime soon. But plainly, in the free expression arena, the use by business of libel law can be problematic. Now, the common law has resisted, both in this country and indeed before the Human Rights Court in Strasbourg, any attempts to restrain the rights of big business to sue for libel. And if that's something you wish to pursue, you're going to have to get the politicians to do it. And it's interesting in that regard that in Australia, there's now a uniform libel law which restricts the rights of companies to sue for libel. And Lord Leicester has this actively in mind as part of his draft libel reforms here. So watch that space also. Third point. Plainly, governments across the planet are fiscally constrained, and the size and shape of the public sector in this country and in other countries is going to change and probably reduce. English law hasn't obviously been adequate to the task of defining the legal framework in which a company that does a job that would previously have been done by government is to be judged. And plainly there's much work to be done, and there'll be interesting cases to be brought. Sorry if that sounds opportunistic, Mark, around this whole space about what's public and what's private. And then lastly, I wonder if there isn't a job for all of us in the room to conceptualize the legal relationship between business and human rights in a different way. I'm a little bit bored by a lot of the discussion about alien torts. I mean, it's become in some respects a bit of a one-trick pony, said he contentiously. I think it can't bear the weight. I'm sure it couldn't bear the weight Thomas Jefferson conceived for it 200 years ago, and I'm not sure it can bear the weight which it is required to bear now. But I think there needs to be some fresh legal thinking, both on the NGO side and indeed on the defence corporate side, in relation to for example, to the rights of Indigenous peoples whose conception of property may be wholly different from our own. So those are my pointers for the future.